Your Honor, pardon to mention for modification of order.
And it's a surfacing
Okay.
matter was last listed in the month of November 24, and there was an order to list from 5th of December. The matter may come up anytime next week. Okay.
Supplementary list, item number 1.
Convicted under section 302 and sentenced to life imprisonment and fine mallet 20,000. 302 and life.
Why this CRLA 223 of 2021 has been listed? Couldn't know. Is it some other case or what? What is the prayer? Insulin order down to 6421.
ये तो खुदना चला आगे वो दिखाई नहीं
Yes. So this criminal appeal single judge bench case was filed when the charge was framed. So that has become infructuous. That charge sheet was filed and that was challenged. And there is a bail application, I think. Okay. So bail application while the trial was under progress. So it has become infructuous. So that was the prayer for us to answer on a really difficult one. Second, select the CRLA number 223, whether the case is pending or we have to know. CRLA number 223 of 2021. This application was filed for bail in connection with city case number 621, February 34th of 2020. While the matter was sub judice before the London trial court, since in the meantime, the trial court has pronounced the judgment and found the apparent guilty. Therefore, the CRLA has become infructuous and according to disclosed documents. Now, CRLA 1030 of 2025 are admit call for the trial court record. Interim application for bail and stay relation of fine to be considered after receipt of the trial court deposition copy supplied. So, this CRLA disclosure to yes, next.
Item number 2.
Wait, please, the government has been convicted under section 302.
Yes, next.
3 SCST is there.
302
3 SCST Act. 302 and 3 SCST.
or item.
105.
Admit present, third admit, call for the trial court record. Since one of the offense under which the appellant was found guilty is under section 3(2)(b) of the SCST. Extra copy of the appeal memo along with the interim applications for bail and stay relation of fine be served on the land council for district, which will be sent to this one, so usual order for the but the interim applications shall be considered as usual legal aid to no. But the admit for the issue notice. Yes, next. How we do judgment the position of the devil, so that's what like.
Item number 3.
Net Vijay. The appellant may have convicted under section 302 IPC for life minute. And both father and son, in state custody, father during trial is on bail and more than 80 years.
Admit for the trial. Okay.
Item 4.
How many persons face trial?
2%.
Who agreed?
Both are found guilty.
Mile.
Okay. ठीक है, next.
Okay.
Item 4.
I'll put the forward item 94 of.
Wait. This year alone. That are condition put regime. Three zero two RI for life. Admit for example, I would say जो serially करी engage कर दे. मैं कहती हूँ list अदर please. Next, CRL number 94. Then admit. Call for the trial court according to application for bail and stay relation of fine to be considered. For receipt of the trial for us. Yes.
Item 5.
What is the jail criminal appeal for?
302, 34 and 120. Life minute.
Hello, admit. Then go to counsel period. Next.
Item 6.
Well, 302. Life.
And
Item 7.
Please. Your Honor, the petitioner had thrown the order of the ombudsman. The order of the ombudsman. That is saying. Annexure 6, on page 51, my lord. Medicinal unit is a telecom service provider. Check minute, my lord. My lord, initially we have challenged their demand notice against before the GRF, and being agreed of the GRF order, we have filed an appeal before the ombudsman, madam. And both the from partly analyze the demand notice and accordingly revise some extent without going through the other aspects of the law, my lord. Medicinal unit is a service provider in the telecom sector, my lord. The towers they have built and acquired and provide after obtaining power supply, they provide the telecom service. My lord. And the GTL infrastructure, who is acquired the previous consumers unit and provide power telecom service, my lord. My lord, admittedly, there is a law that we have to pay the arrear of the previous law. It is one aspect, my lord. The other aspect of the law is that, may I read, my lord? Section 56, 2, my lord, Electricity Act 2003. There is a provision. May I read, my? 56(2). Notwithstanding anything contained in any other law for the time being in force, no sum due from any consumer under this section shall be recoverable after the period of 2 years from the date when such sum become past due, unless such sum has been shown continuously as recoverable by the arrear of charges for electricity supply, and the licensee shall not cut off the supply of the electricity. Here, my lord, they have charged the demand against the electricity dues from 2009 to 2014, my lord, July 2014. We have acquired the unit. Thereafter, we applied for a fresh connection, the new connection, and they insist us to pay the area due of 6 lakh some odd.
That what was stated there.
No, my lord. Here, my lord.
Page 56.
My lord.
Last point is that demand is barred by limitation on the.
Demand is barred by again. Ombudsman, lordship, I kindly glance the ombudsman order, my lord.
So it comes that where this aspect, the point which you are raising, is also been raised before the ombudsman.
My lord.
Has been dead and the content was modified. So from what now has been decided.
They have the law and ombudsman. If I place the ombudsman order, my lord, that is observation in ombudsman order running page 56, my lord.
Paragraph, this point has been dealt with. The demand, written submission, see,
Yeah.
the demand is barred by limitation under section 56 of the Electricity Act.
But then
Apart from other
Other points.
Formulated by the your point,
my
and then dealt one by one. So this point is.
ombudsman not dealing with, my lord. Ombudsman 56 and observation part, my lord. That is conciliation failed. Power supply was initially given to Mr. Disnet Wireless Limited, having consumer number so and so. Disnet Wireless Limited was finally taken over by the DTL infrastructure, the present petitioner, through merger acquisition takeover before the 2099. Hence, it is instant case regulation 10(2) of the OAC Distribution Company Supply Code 2004 is applicable, which states as under. We are not disputing that, my lord. But my lord, where applicant has purchased existing property and connection is lying disconnected, it shall be the duty of the applicant to verify that the previous owner has paid all dues to the licensee and has obtained no due certificate from the licensee. In case no due certificate is not obtained by the previous owner, the applicant before purchase of property may approach the engineer of the licensee for a no due certificate. It is understood that no due certificate was neither obtained by previous owner nor by present applicant. Therefore, power supply to the site can be extended only after clearance of all outstanding dues against the previous consumer, my lord.
You agreed that, on whom you, over, or the merger document must have been stated that you will pay the, all these things, very that.
The document is, my lord, liability I'm ready to pay the money. The question is whether the liability they have demanded by the licensee, my lord, can override the section 52, my lord. When the due is since 2014 and they have demanded 2024, my lord. That is one part. Apart from that, this is a electricity supply. Electricity is to charge basing on the supply of the quantum of the electricity. May I point out that regulation 86, my lord, 2004 code. How they charge the electricity, my lord? It is the mandatory provision. May pardon, my lord?
And you applied it to 2024.
My lord. My lord,
This is the now the outstanding due.
the outstanding dues is I am ready. Outstanding dues, whether that is lawfully correct or not. Because 86 provision may place, my lord, 86 regulation. Because licensee has to take my the demand charges basing on the quantum of the electricity they have supplied. Here, my lord, the provision says 86 energy charges. My lord, these are not taken over by the London Lawrence. My lord, I am submitting that, my lord. These are the mandatory provisions that are not taken care by the Lawrence from below, my lord. Because the bill itself is erroneous, my lord. Because energy charges as prescribed in the license tariff shall be payable by the consumer on the basis of actual consumption on the energy. My lordship's attention to the annexure 1, my lord. Kindly glance over the annexure 1. Annexure 1, running page 20, my lord. Para. Para 5. The exact date of disconnection of power supply to consumer number so and so is not available with the respondent. The petitioner who had taken over the asset long after the billing was stopped is unable to provide any document or evidence regarding the date of disconnection. In this context, after observing details vividly, the Lawrence GRF have directed the respondent for a file inquiry. Thereafter, the respondent made a field inquiry and submitted the report before the GRF, where it mentioned that power supply to site is lying disconnected since October 2013. They have taken it consideration. Accordingly, the Lawrence GRF has passed the order on 27th January 2025 in case number so and so. So this authority is not inclined to interfere with the order of the Lawrence GRF Barampur. Hence, my lord, here is two aspects. One is there is no data available with the licensee or the consumer regarding the disconnection of power supply, because calculation of that. Yes, I admit, my lord. I am not disputing that, my lord, disconnection part. The question is, thereafter the modality of calculation, they have not taken into consideration the Lawrence GRF or the ombudsman, my lord. That is why I am placing the law, my lord. Lordship kindly just pay running page 20, my lord. Annexure 16. Running page 20.
We will calculate whether this is wrong or illegal.
No, I'm not paying my number here because rejurisdiction has no scope to calculate. I am placing the law, my lord, because the Lawrence forum below, whether that is taken into care or not. That is I'm submitting, my lord. My lord, there is a concurrent judgment because law states that they cannot charge the bills on assumption basis. What is the modality? They have to calculate the bill basing on the quantum of supply. Lordship, kindly glance running page 20, my lord. Kindly. They have not, no, my lord, GRF, neither GRF nor the ombudsman have dealt with that, my lord. GRF says you have taken the disconnection period, the filing date, my lord. That is October 13 is the filing. Thereafter, the power supply is disrupted. Those from that date you have calculated. But what basis? Lordship kindly can running page 20, my lord. Column 3, bill units, my lord. Completely total billing power supply is available from 2009 to 2000. Provisional bill. Right, my lord. Now, Lordship, may I am placing the provisional bill. Provisional billing, my lord. May I submit, my lord. That is 93 payment, regulation 2004, 8. Provisional billing. The amount thus billed shall be adjusted against the bill raised on the basis of actual meter reading during subsequent billing cycle. Such provisional billing shall not continue for more than one meter reading cycle at a stage. And here to
Problem is either you have data now, they have data.
no, I have data. I am placing that. I am placing that matter. From 2009 to 2014 July, they have TPSOD.
calculated for within that period. We taken of this of the month of December 2009. And it came has been done till July 2000. The opposite party, the reply before the and CRM submitted that the reading of the consumer and the 7 July 20 was scheduled out. Second question thereafter, the message action was permanently disconnected since August 2008, the outstanding cases amount of the 630 possible right of the 99 so as how that is used in application. It's will also be contention of the opposite party that's in our supply from the benefit from the parts of the premises of the petition can be explored only after the payment of the outstanding electricity. This is for regulation 183 of these PRC distribution condition and supply of 2019. The current GRS the functionality for area and consider for the connection. One to divide the electricity bill, it's not the distributed period, December 2009 to June 2011, based on factor rate, data reading, and actual consumption, to compensate the financial losses suffered by the petitioner, to consider the new easy connection of the petitioner and the side. But fish is good parts of that. Good parts of that. In good man, opposite party. Filed the objection. Contrary on the grounds that the complaint was registered before the GRF existing number 490 the ground that basis is not whether it's limited because the consumer having consumer number 21100102029 which was disconnected since long. And it was requested to reconnect the power supply to the correct need for reconciliation of the division of the grid for failure and reconnection of power supply. Instead, whereas private limited availed the power supply from 16/10/2009 and the consumer was being given July 2014 and thereafter the electricity connection was permanently disconnected from August 2014 and the year of 6,37,529. It was further forced before by the opposite party for the current ombudsman that since the power supply, the consumer has been disconnected for long, payment of the outstanding electricity power supply to the premises of the consumer can only be disposed of the payment of and essentially due as per regulation 1/8 of the year. We are substitute some condition of supply of the time. Stop. The Englishman the points raised by the petition, which are as follows. Would be paragraph 11 convention commission. The letter movement will be all the points raised and the petition and taking perform regulation of the OERC distribution additional supply of the compared that since the creation of physical has taken over the consumer has taken the tower from Mishra's District Wireless Limited to margin of the acquisition, the takeover before 2019. Is liable to pay the area fee. Regulation came to the VRC distribution of 2004, only of 2000 regulation came to of 2004 rates as follows. 4%. It was found by the ombudsman that neither moving certificate was obtained by the previous owner or by the petition. It was further found that the petitioner existed the engineer EPSOPA for new connection to the site in November 2024, which was more than 10 years since the bidding was stopped on in the month of August 2014. And therefore, at the request of the petitioner, division of the deed was made into 24 in accordance with Regulation 157 of the 2019 we as distribution by the condition of supply of the contention which was raised by the petitioner before the ombudsman that the exact date of disconnection of power supplies by human numbers one is not available has also been held and it was held that since the petitioner has taken over the asset long after the deeding was stopped and was unable to provide any document or evidence regarding the date of disconnection, the Reliance GRF directed the opposite party for a field inquiry, and the opposite party made the field inquiry and submitted a report before the GRF, wherein it was mentioned that the power supply to the site was line disconnected since October 2013. And accordingly, the order was passed by the Reliance GRF. Stop. It was held by the ombudsman that there is nothing wrong in the order passed by the Reliance GRF. Okay. Accordingly, the representation case was dismissed. The Land Council from the petitioner argued that in view of section 56(2) of the Electricity Act 2003, which says that anything concerning any other law for the timing imposed, no sum due for any consumer under this section shall be recoverable after the period of 2 years from the date when such sum became past due, unless the sums have been shown continuously as recoverable as the year of charges for electricity supplied from the demand of the opposite party. The party for the period from the area bills from the period of 2009 to
July 2014
July 2014 was not justified
Even the apex total
stop. The Land Council for the
I have quoted that in para 2
the Land Council for the city. The Land Council for the petitioner also placed, what do you
provisional bill test
engineer,
the provisional billing test with regard I'm actually
when it was heard that the new state was taken to recover the fuel costs of the fuel, where we applied. In the case in hand, going to the warrant, so we find that the petitions thus taking over the merger acquisition by merger of this acquisition, the assets of the snake were discriminated. And therefore, he was required to pay the electricity bill outstanding. Since the petitioner has put not produce the no use certificate from the previous owner. And he has also not obtained the no use certificate and applied for the new connection to the site in November 2024. Therefore, this provision is not applicable. We are of the view that it was a continuous cause of action and the ratio return in the decision of the smart zone is not applicable in the factual scenario of this case. According to the requisition being given of that.
May I please one thing? With the Lordship's permission, my lord. Line, my lord, please. The licensing not consider the average billing, my lord, because there is no such law. They have to charge average billing, my lord, and by that point they have get a free hand to charge any from anybody, my lord. There is no quantum of electricity they can charge anything. That part is not deal by the forum bill, my lord.
Item 8, the petitioner is the Union of India. I seek some time because here is a case relating to the two scheme, that is TVP and PCR. And now what happened in this case, in different High Court has passed different orders against which the SLP was prepared, SLP was dismissed. But this case is different to that case, that I want to examine, my lord, because this count will be done according to taking the length of service. 16 years, 26 years. This is the scheme. Wise length of service will be count. So let me keep it to any day after 1 week or after vacation. So let me keep it 10 next week because they have filed the contempt. Next week.
18/12/2024,
Again.
the order was passed
Yes.
and the time limit was fixed that the entire exercise is to be completed within 3 months.
What happened in this
The date
case?
of
Because
receipt of the order.
what happened in this case? Department initial think that it should not be challenged because a similar quoting person has already get. Supreme Court has dismissed the same, so we can settle the same. But
You have just filed the writ petition. So now it has been listed for the first time,
first time, yes.
and that a content petition has been filed. Now you will make a submission that since the writ petition has been filed and it has been posted to so and so, this content petition hearing be deferred. That would be your ground. We'll say that the tribunal is at liberty to proceed with the content petition. That order will pass. It takes time.
You know what I'm praying, my lord. Let's you keep it after 1 week after. In the meanwhile, I'll submit the documents. What is the length of service basing on which other court can
Petition
interfere?
has been filed challenging the order dated 18/12/2024, passed by the London Central Administrative Tribunal, Cutter James Cutter, in OA number 288 of 2021. On perusal of the impugned order, it appears that in the operative portion, the London Tribunal has directed the petitioners to grant financial upgradation to the opposite party. Opposite parties कर दूँ चलो.
They are committed before Supreme Court that they will pay. अपन देखिए थी.
Opposite parties under PPOP scheme after completion of 16 years of service, and under BCR scheme after completion of 26 years of service, from the dates from which their juniors are granted such financial upgradation. And it was also directed by the London Tribunal that the petitioner shall revise or refix the pay and consequently revise the pension and other retirement benefits of the opposite parties and refund them the excess amount recovered or withheld from their gratuities, etc. And the entire exercise to be completed within 3 months from the date of receipt of the order. In paragraph 10 of the impugned order, it appears that the petitioners committed before the Honorable Supreme Court that the benefits of the judgment which was passed in respect of similarly situated persons before the Hyderabad bench as well as Calcutta bench shall be extended to all such similar employees who are similarly situated. And they cannot deny the same and withdraw the benefits already granted to the opposite parties. Stop. It is stated by Mr. Fari that a contempt petition has already been filed by the opposite parties before the London Central Administrative Tribunal for non-compliance of the order dated 18/12/2024, which is sub judice. Stop. It is made clear that the pendency of this writ petition shall not be a ground for the London Tribunal not to proceed with the contempt petition. A copy of the order be sent to the registrar of the Central Administrative Tribunal, Cuttack bench. Yes.
Like only one sentence may be reflected in the order that this is a discrimination of the case is that the length of service could not be taken into consideration by the
No,
tribunal.
no, before you filing the writ petition, you have to, you should have checked it. Whether
No, we have
covered or
checked
not
it.
covered. You are not sure.
Yes, next. Yes, yes, next.
Item 9.
That's why I, on behalf of Mr. Subrat Mishra, for the opposite party ban, actually kindly taken up this matter because he is
Kindly.
taken up.
Who is for the petitioner? What is your prayer?
We are not, auction was, demand notice was 7,45,000. I was approaching for the OTS. And
No, surface side proceeding has been initiated. So,
Initiated.
e-auction sale notice was issued
Yes,
and that date was fixed for 29/7/2025.
well,
What happened?
our auction has not been, as per instruction, no auction has been taken.
Not successful.
So approach the bank,
Yes,
like the
for OTS.
petitioners have filed this writ petition with a prayer for a direction to the opposite party for consideration of the one-time settlement. Stop. It appears that from Annexure 5 that e-auction sale notice in respect of the property has been issued and e-auction sale date was fixed to 29/7/2025. We made a query to the London Council for the petitioner regarding Mr. Das, regarding the status of such e-auction sale. Mr. Das submitted that he has instruction that it has become unsuccessful and therefore the petitioner intends to approach the bank for one-time settlement and he may be permitted to withdraw the writ petition. Accordingly, the writ petition is disposed of as withdrawn. It is open to the petitioner to approach the bank for one-time settlement.
Pardon.
Yes.
Not until such exercise is made, it is my residential house.
We do not know the
Pardon?
do not know that what is the outcome of that. He is not telling anything.
If-
You are not aware about the outcome of the, you are for the banks.
No, sir. Because
Not if not taken,
Yes.
not, no.
You are
policy.
making a positive statement and we have recorded it. And if it is
Yes.
found to be not correct,
Yes,
then
I got,
the-
I found it.
yes,
Yes.
next, item number 10.
No policy, that's it.
No.
Item 10.
Maintainable you. Yes, item
Item
number
10, I beg your pardon, Your Lordship, may adjourn this matter to any other day, Lordship, on behalf of Mr. Pramod Kumar Naik.
Here matter property has already been sold out. Sell certificate has already been granted in favor of the auction purchaser.
The writ petition has been filed by so and so with a prayer. For a direction to the opposite parties number 1 and 2 not to take coercive measure against them. The Mr. Sahoo Land Council appearing for the which bank it is?
Below the College Road Bhadrak branch.
Union Bank of India, huh? Bank of India, College Road branch, Bhadrak, submitted that in the meantime, the e-auction sale is successful and the sale certificate has been issued.
Why these people are not sitting? Councils are coming and giving it.
I am repeatedly telling you that why they are sitting outside and sale certificate has been registered before the sub-register.
Millard.
Okay, he has produced the relevant documents which are taken on record. In view of the this pendant's development and since alternative efficacious remedy is available in view of the decision of this one, so we are not inclined to entertain this petition. It is open to the petition to seek a body in accordance with your obligation.
Item 11,
Monday to take instruction. The sale is occurred on 29/8/2025 and the sale is confirmed.
Is the case mirror where there was an OPS settlement.
Sale is confirmed.
Mr. Ishwal Anjan Kumar Vishwal Land Council appearing for the Punjab National Bank has filed a memo wherein it is mentioned that the surface proceedings started against the petitioner and the mortgage property was put to auction on 29/8/2025 and the successful bidder, namely Jyotsnanjali Mangaraj, Bantara Dharmasala, Botka Jajpur, has deposited 25% of the bid amount and the bid price is 98,50,000 and the sale confirmation has also been issued in our favor on 30/8/2025. The memo is taken on record in view of the such memo since the petitioner has got alternative remedy to challenge the aforesaid sale and issuance of the sale certificate and in view of the decision of the Honorable Supreme Court, the expedition is disposed of giving liberty to the petitioner to avail the alternative remedy. Yes, next. Mr. S.S. Rao and senior advocate for the petitioner is present for the one. Yes.
item 12,
Petitioner challenge the order of a tribunal approach before this honorable court, my lord. I can lecture 1, page 8, and this honorable court, I will watch the order and directly remitted back the case adjudication of the OML. That was disposed of since 7/4/2016.
Registry to face adjudication. What is your prayer? Where the opposite
Transfer the OML. Transfer the OML disposition.
Transfer the oil?
Which way?
OML number TS 4/2011
All the cases have already been transferred.
ସେଇଟା ଡିସ୍ପୋଜ ହେଇଛି ସବୁ 7/4/2016 ଡିସ୍ପୋଜ ହେଇଯାଇଥିଲା
Huh.
କିନ୍ତୁ ସେଇଟା ଆଉ ଟ୍ରାନ୍ସଫର
Once disposed of, why should it be transferred?
by virtue of the order of this one.
No, no, the matter has already been disposed of.
Was disposed of.
So only the question of transfer then, the
They-
matter which was pending, only those
That has been
cases.
transferred, my lord.
So once it has been disposed of, why you are praying for the disposed of case? You can challenge that order. Which has
Challenge
been
gala,
passed.
say order challenge gala, but this honorable court by answer 1 my lord remitted back to fresh adjudication. ସେ ତାପରେ ସେଠି ଅଛି ଟ୍ରିବ୍ୟୁନାଲ ଫାଇଲ ଏଠି ଆସିବ
ଆଚ୍ଛା ଆଚ୍ଛା ଆଚ୍ଛା।
ଫେଜ 10 my lord.
ସେଇଟା remit ହେଇଗଲା ପରେ pending ଅଛି।
In transition period, the abolished.
In between.
The petitioner challenging all of this wants to cause the pain. In no from dismissal moving around the 4 month delay, the tribunal is not certain. It is a liberal function. It goes down from that of it. So that is T number mane kon? Orissa administrative tribunal T number ଲେଖା ହେଇଯିବ।
तो OA C होउची B होउतला।
No, after remand it must be pending. After the remand by this court,
My lord.
the OA must be pending there.
My lord.
It might have come. You verified.
ସେ ପିଟିସନ ଭେରିଫାଇ କଲା ସେ କହିଲେ ତମେ କୋର୍ଟ ଅର୍ଡର ଆଣିଲେ ଫାଇଲ ଯିବ ଏ ଯାଇ
It is remanded, then obviously it is pending there.
adjudication like କହିଲେ ସେ କହିଲେ କୋର୍ଟ
अच्छा
Report last
report magidro. This writ petition has been filed by petitioner Krishna Das for a direction to the opposite party number 5 to transmit the records of P number 104 of 2011. Are you sure the number is correct? Which was filed by the petitioner before the opposite party. For adjudication by this court on merits. It is the contention of the land council for the petitioner that the petitioner filed WPC number 18582 of 2018 before this court, challenging the order dated 7/4/2016 passed by the by the opposite party number 5 in T number 104 of 2011. 2001.
1 लिखा है।
2011
Order लिखा है 1
लिखा है।
Order supposing 2011.
Paragraph 1.
1 की
11 page 8 है my lord. ये cost type तो
Cost type
11 or
11 अच्छी prayer में भी 11 अच्छी 1 ही मत हो जाओ which was dismissed on the ground of limitation. This court had order dated 8/8/2019 set aside that order and remitted the matter to the opposite party number 5 for fresh adjudication. The land council for the petitioner submits that since the opposite party number 5 is ceased to function and all the records have been transferred to this court for adjudication. Therefore, the T number 104 of 2011 was also required to be transferred to this court for adjudication. And the records are still available with the opposite party number 5. Let a report be called for from the registrar. Registrar to ye ki nathibo ki
Anyone is functioning? Say, good option the officer.
So, register of opposite party number 5 or whosoever in charge of opposite party number 5 to submit a report regarding availability of the records of T number 104 of 2011. And if the same is available with the opposite party number 5, the same shall be immediately dispatched to this court. The report should reach this court on or before Ajiyalla bar 19th matter be listed on 24th of September 2025. This order be placed before the Land and Register Judicial, who shall send communicate the order through email to the opposite party number 5.
The registry of this court shall also be verified to verify whether the file has reached. The registry of this court shall also verify the aforementioned aspect as to whether the file has already been received from the tribunal, or not.
Yes. Your Mr. Rivers.
Item 13.
You are appeal.
I am from the bank.
What has happened in this case?
My lord, they have filed a estimate before the DRT.
DRT.
Pending there, but they have again approached here to pass an order in the securitization proceeding. Position letter.
Postal position and
That is matter, the prayer matter can come to pay is. They are also in, before this honorable court, before in WPC number 1069 of 2024. At that moment, my lord disposed the repetition.
No, this letter was issued during the pendency of the So they could have filed.
Yes, ma'am. They should approve there, my lord.
Why they have again approved this court?
And that is pending there.
What is that SN number which you say pending?
That SN number, my lord, they have mentioned.
Read petition ne likhi na di
Yeah,
number
ऐसे लिखी चल रही नंबर लिखो.
No, mention. The para 14, my lord.
खाली ऐसे ऐसे लिखचन
ऐसे नंबर
में ये जो DRT रो जो उटा देइचंदी से स्लीप ट्रांजेक्शन 6 रे सेठी देखौची रेफरेंस नंबर हमको संको डायरी नंबर टा देखौची 796 of 24 সেটা এখন সেই স্টেজে ଅଛି না
না ইস্যু নোটিস ଦେଇଛି, they have mentioned it.
তাহলে ডায়েরি নম্বর এটা এখন দেখুন এসএ নম্বর হওয়ার কথা এটা কেবেকার ইনফরমেশন 3/9/2024 পুরোনাটা এটা ক্যান ইউ কালেক্ট দি এসএ নাম্বার
না,
তো
You know, on the basis of direction given by this court, an
Yeah.
essay was filed. We have given the direction in writ petition number 106 of 96.
and that is disposed of.
Yeah. Posted clear.
হুম,
Posted clear.
For council to have, they will file a OTS proposal before the bank and withdraw them.
And
They will do
further,
that.
the writ petition number so and so, and by virtue of this court's direction, the petitioner has filed the essay.
That is my lords, this that is in page 15, my lord, annex 7, 10697 2024. They have annexed the order, my lord.
Right? Page number?
Page number 15, my lord. Running page. Annex 7.
Order annexation. Annexure 1.
এই তাদের তো এসএ নম্বর লেখা হয়নি
ને ସେଥିରେ ଯୋଉଟା ଡିସ୍ପୋଜ ବାଲା ୱିଡ୍ର କଲେ ସେମାନେ
হুম হুম
ସେ ଅକ୍ସନ ଇଏ ଚାଲିଥିଲା ଅକ୍ସନ ହେଇନଥିଲା ବୋଲି ସେ ୱିଡ୍ର କରିଦେଲେ ପୁଣି ଏଗେନ୍ ଓଟିଏସ୍ ପ୍ରପୋଜାଲ ଫାଇଲ କଲେ that was rejected again position letter then they approach the DRT but
ଏସଏ ନମ୍ବରଟା ରଖିଦେବା ଆଣିବେ
I
ସୋମବାର ଆଣିପାରିବେ
ଆଜ୍ଞା
ଲେଖନ୍ତୁ non appears for the petitioner. The petitioner has challenged the notice dated 4/8/2025 issued by the bank, opposite party bank, for example, Canada Bank, no? For vacation oblique peaceful possession of the property.
Essay number 2. Page 30.
It's 30.
Legal proceeding and the interference of the honorable court and subsequently DRT case number essay number 26 of 2025.
It's active.
30.
Subsequently DRT
And local schedule also.
ଅଛି ତ ଏଇ ନମ୍ବରଟା
Is there?
ଏସଏ ନମ୍ବର 26 of 2025 ଦେଖିଲେ ପେଜ ନମ୍ବର
Page number 30 annexure 5.
I'm sure. Mr. 500.
In his representation to you, he has written
Yes, 26 of
26, 20,
Yes,
25.
କଣ ଲେଖିଲେ ଚ୍ୟାଲେଞ୍ଜ ଦି ହେଲା ନୋଟିସ ହେଲା ହଁ for vacation and delivering peaceful possession of the property. Of the land with property bracket linked on the secured asset. Stop. Mr. Das Land Council appearing for the opposite party bank submitted that as per the direction of this court, the petitioner has filed essay number 26 of 2025 before the, which is sub judice before the DRT. And the petitioner can file an interim application if he so desires, challenging the aforesaid notice issued by the bank dated 4/8/2025. And since he has got alternative remedy, this petition should not be entertained. Strong. In view of the fact that essay number 26 of 2025 is sub judice before the DRT and DRT cutter. And the prayer made, we dispose of the bridge petition, giving liberty to the petitioner to approach the DRT.
Pursuant to the order dated 31/7/2024 in writ petition number 106. Pursuant to the order dated 31/7/2024 passed by this court in writ petition number 10697 of 2024. The SN number 25 of so 26 of so has been filed, which is pending.
Yes, next. This one. Open like the non-appeals.
Item 14.
Please, your lordship. Lordship, I mean, DC, I have some throat infection, your lordship. May I permitted to withdraw and liberty to approach before the London DRT.
The land council for the petitioner seeks permission to withdraw the petition to approach the land DRT. I am appearing on behalf of Mr. Niyamati. Mr. Kichi appearance memo file करना थी.
Memo.
Yes.
Memo ta file कर दूँ. Case ta dispose of you can get your bills.
For obvious reason, you have to file it.
Okay. Good. File कर दूँ तो कहाँ की file करिए. Yes sir. अच्छा. हमें लेट कुछ यदि file करिए रही हो ना line टा काटी दो.
Actually, your lordship, Mr. Niyamati is adjacently put up with another matter.
Good appearance memo
Mr.
file
Niyamati
करिए.
come.
Mr. Niyamati is now withdrawing the writ petition. You file your appearance memo, will just indicate it.
Well,
You file the appearance memo.
Now you understood.
Yes.
just he has joined. Mal.
Okay.
Only one month back.
ठीक है.
He doesn't know the
Sorry,
trick of the trade. So
I'm trying to make it fly.
All right, next. Give that.
Okay.
Item 15.
In this case, what has happened?
My lords, I have instructions to appear on behalf of
On behalf of whom?
State Bank of India, my lords. You're the opposite party.
Please give him a petition. And what is your prayer here, Mr.?
What has happened? I have purchased a plot from the Cuttack Development Authority.
Year 80 order you are challenging. Confirming DRT order.
Reversing.
Reversing.
DRT has passed directing that the sale is mortgage cannot
So
be.
you want that the order passed by the DRT should be confirmed,
restored.
So please give him a.
I will
take up this matter Monday or next week, Wednesday. Wednesday.
Can I kindly give a copy because they have
No,
paid
listen.
the stress assessment.
Copy, but tell your name, ma'am.
Mamta Tripathi.
He also submits that she has instruction to appear for State Bank of India and file the wakalatnama by Monday for those. Let a copy of the Mr. S.S. Rao, senior advocate, is present. Let a copy of the petition be served on the land council. During course of the day, yes, I put up this matter on 17th. On 17th.
I have prayed for state, let it come on 17th.
Which password which?
Item 16.
Still, your lordships, an application under the Insolvency Act to declare as insolvent has been filed in the NCLT Cuttack. In that application, we file a preliminary objection which the Act allows, that if it is not maintainable there, because the jurisdiction under the IBC code is that if there is a debt, undisputed debt, and there is a liability to pay. Suppose there is a disputed claim, a person may have a suit or an arbitration. Only when there is an undisputed debt that an application is made to. That's the basic.
Who are you?
Your Lordship, against whom an insolvency application has been filed. They claim that I'm a corporate debtor. I have defaulted in
Section 7 petition.
9. So we file an application. The application has to be heard first according to the Act and also the various case laws. But the impugn order, Your Lordship, may I read? Page 53. Page 53, Your Lordship. Part of Annexure 1. Did Your Lordships get it? Your Lordships, the bottom portion. May I just read it, Your Lordship?
Yes.
The application has been filed under Section 65 of the Insolvency and Bankruptcy Code 2016, seeking stay in the main company petition. Learned counsel for respondent is permitted to make submission while replying to the main company petition on the next date of hearing. So they have clubbed the main hearing with this. Now, Your Lordships, may I take Your Lordships to the provision? Your Lordship, that Act is here, I can see.
So your application will be heard on that day.
No, Your Lordship, that's exactly what the law is.
It's already over.
They are saying that they have clubbed it with the main hearing. That is what the case laws and
what
also
happened
the
on
Act
main
does not allow.
You tell that NCLT that.
We have filed several, that got rejected. This is a rejection prayer.
What happened on 10/9/2025?
They have commenced the hearing, Your Lordships.
So?
That's the problem.
Precede the 9 petition, your application should be heard. That is your case.
Yes.
That's your case.
Before the main cases.
That's right. Precede Section 9 petition, your application is to
But
get.
they have now rejected that prayer. And they said.
There is no rejection.
Yes,
Say
Your
that we
Lordship.
hear together.
Because it's the main company petition, they said. They've clubbed it with the main company petition. We have filed an application on the preliminary ground. Your Lordship, may I just show the provisions, if I be permitted to? First, Your Lordship, this is Mishra book, Your Lordship. If there's no second book, we'll give our book, Your Lordship.
Yes.
No, yeah, we can read it. You please read it.
Which
Your Lordships, may I take Your Lordships to first section 6? Probably have section 6.
You have it. Yes.
May I just place it? Your Lordships? When any corporate debtor commits a default, now this is very important. When any
Section
corporate debt, 6 is that
Okay.
provision, the substantive provision, where any corporate debtor, that means there has to be a debt, commits a default, a financial creditor or an operational creditor or a corporate debtor itself may initiate corporate insolvency resolution process in respect of such corporate debtor in the manners provided in the chapter. Now, Your Lordships will see section 311.
If you don't reply to the notice, presumption operates. That is an admitted liability. It has to be heard. Have you replied?
Your Lordships,
Have you replied to the notice?
Your Lordship, I'll come to the facts of the case. I'll come to the fact. Everything has been replied.
No, why will enter into all those things when the matter is sub judice before the.
Your Lordships, I'm not taking Your Lordships to the merit of
What
the
has
matter.
happened on 10/9?
Your Lordships,
Probably the order sheet that what has happened.
Your Lordships,
What is not important?
Your Lordships, order has not been uploaded. But Your Lordships, what we are saying is this. We have come up against a prayer which is supported by section 9.
Have you disputed in your reply to the notice
Yes,
that
Your
the
Lordship,
liability
it's a
is
disputed claim. It's a contractual contract. It came out of a contract for sale of some mines.
so was your reply? So was your reply?
May I just show section 9 first? Because if I don't have a claim under this act itself, then probably section 9, Your Lord. Section 9 is where the application has to be made. Your Lordship will see section 9(5). So when an application is made, what is that the adjudicating authority is supposed to
The
do?
prayer in this petition is to quash the order dated 7/8/2025.
Yes, Your Lordship.
right?
Yes.
Which is the order which was passed
Annexure
on
one.
7/8/2020?
Which I placed, Your Lordships, page 53.
That only says that we'll hear your application along with the.
That's why, Your Lordship, I'm showing section 9. Your Lordships will understand that what is the issue here. And also show the case laws on that point.
Yes.
So, Your Lordship, section 9 is where you make the application. And when an application is received, section 9(5) triggers. And Your Lordships, we are covered under section 9(5)(2). May I just read? Your Lordships will see section 9(5). Did Your Lordships find the provision? Yes. 9(5)(1), Your Lordships will see. 5 I'll read. The adjudicating authority shall within 14 days of receipt of an application under subsection 2 by an order admit the application. 1 is about admission. 2 is about rejection. So one of these things they have to do. 2 is reject the application and communicate any decision to the operational creditor and corporate debtor. In which case, if Your Lordship D, notice of dispute has been received, notice of dispute has been received by the operational creditor,
All this will occasion.
or there is a record of dispute in the information utility.
That's right. All this will occur after satisfying 9(1). 10 days preceding the notice, you have to reply.
Correct. Reply.
Show us the reply. You have
We
to
reply, Your Lordships.
Reply.
That is.
Okay, actually, 82.
82.
Was not questioned.
Then the 9.
82.
82. To their section 8 notice, this was our reply. May I place the reply, Your Lordships?
80.
82, Your Lordships.
When was the notice?
Notice was 19/9/2024.
Have you given within time period?
Yes.
Yes, Your Lordships.
When is the date? Date? Notice dated?
19.
19, see the upper left hand.
No, 19.
9/2024.
Your reply?
Your Lordships, 11/10/2024. And this arises of a contract of for providing some goods.
Fine.
May I-
Even while deciding section 9, the court has to arrive at a conclusion. The tribunal has to arrive at a conclusion whether it is admitted liability or disputed liability. That let it be done.
That's
Your
exactly,
application.
that's exactly what.
See, your application in the form of your reply to the section 9, in the form of that. You have to argue that
Your Lordship,
along with your main application of 9.
May I place the case?
What is the
law here?
prejudice caused to you?
Your Lordship, the prejudice, Your Lordship will see that I have shown the procedure. I've shown what the moment they receive a application under section 9.
The procedure
They-
generally NCLT, all these applications are heard together.
Your Lordship,
This is the general-
no. Yes, that's not what is happening all over India. May I show the case? That's not exactly what is happening all over India. It is. May I show the case laws?
But my experience is otherwise. That's what I'm saying. Such applications
We
are
just
heard together.
quoting that no adverse order has been passed, so you go and.
Yeah, Lordship, look at page 236, Your Lordships. This is one of the orders of Karnataka High Court, Your Lordships. Precisely, this was the point. Your
But
Lordship,
the court doesn't, the tribunal doesn't say that your application will not be heard.
Your
It
Lordship,
says that it will be heard along with the main section 9.
no, that's not what they say. It's a jurisdictional fact, Your Lordships. They do not have the right to take up that application if there is no debt and failure of payment.
At the time of deciding section 9(1), whether the tribunal has to decide your application has to be seen and has to arrive at a conclusion, it is a disputed liability or not.
No, that's exactly what our prayer was.
So that will be heard. What is the
Your
wrong in
Lordship, the
it?
problem is,
No.
they have said you reply to it while you do not raise it as a jurisdictional issue. You reply it when you are arguing the main application. But the problem here is the law is otherwise. The 9 itself says that when you receive an application, Your Lordship, they said that 9, when you receive, you yourself take a decision on your jurisdictional point, Your Lordship. If they don't have a jurisdictional, if the jurisdictional facts are not satisfied, they do not get the jurisdiction. If there is no debt and no liability, they don't have the authority to take up the main hearing. Your Lordships may just look at the case law on this point.
You
Your
can't
Lordship,
preempt
look at
that.
page 236.
You can't preempt it.
Your Lordship,
Tribunal definitely will decide.
Your Lordships, we made Your Lordships, Your Lordships, the problem is this, that the moment an insolvency
We could have
application-
intervened. We could have intervened if your application would have been dismissed. The
Nothing
court
has
only
been
says that it will be decided. What is wrong in it?
We are saying it has to be may I just show a similar instance in Karnataka High Court? May Your Lordships just look at page 236. 236. Did Your Lordships get it? 236.
Here this order was passed.
Yes, Your Lordship.
So here nothing has been done.
Your Lordship will see. Your Lordship will see.
Your application,
No.
your application under section
This-
65.
No,
60 sub plus 5.
60.
Read 60 sub.
Your Lordship said they have not in the Karnataka
Read
Court.
your application. Read the provision. 60 plus 60 Court application will be provided. This application will be contained in any law. By the time it goes, national procedure will have.
Item number 17.
Item number 17.
In this case, my lord was pleased to engage me in the amicus curiae.
Yes. How many years he is in custody? Yes, Mr.
Date of arrest, my lord. You are arrested on 26.
The trial court record is here. Trial court record is the final form range that he was taken into custody. What is his name? Mangal Munda. Mangal Munda Bakuchi 26/2004.
Yes.
So it means 20 years he has already remained in custody.
He is also involved in some other cases.
No,
In this case.
And the order sheet of the London trial court indicates that they were all along in custody and produced before the London trial court till the Sessions trial was disposed of. Right?
Yes.
We have verified this.
And the present petitioner confessed before the magistrate that he, along with other accused persons,
Registry adjudicated whether the confession was voluntary in nature or some kind of pressure was put on that.
No, that part was also learned magistrate.
Yes, sir, that is to be finally adjudicated.
Appeal.
We are on bail. We are not deciding the matter on merit. Fact remains that all the time accused persons are produced. Left comes. IN number 133 of 2019 is an application for the from heard Mr. Ajay Kumar Pradhan, Land Council for the appellant and my plan and additional government advocate. It appears that in connection with this case, the petitioner was taken into judicial custody on 27/6/2004, which will be evident from the final form. Stop. The order sheet of the London Trial Court indicates that the petitioner was never released on bail during trial. And therefore, the petitioner has already undergone sentence of more than 20 years. Though paperwork has already been prepared, but since the matter cannot be taken up at an earliest, let the petitioner be released on bail. Fixed terms and the terms and conditions shall be fixed by the London Trial Court. Order be communicated to the London Trial Court, and a copy of the order be also handed over to the London Council for the state, which will be forwarded to the concerned jail superintendent.
Not wanted in any forms.
That is, he is the subject without all issues such a thing. Obviously, se sabu case re bail no hele bahari honi jail. A case re bail suppose pasta case pasta case
obviously.
So a case re मैं दे दूँ वाला था. Next.
Item number 18.
Applicant is convicted under section
But it is I filed for correction of the cost.
सोमवार लास्ट सोमवार से ହେଇଗଲାଣି
ଏଇଟା pending ଅଛି.
ଏଇ ଲାଷ୍ଟ ଡେଟ୍ ରେ ଥିଲା ଏଟା ମାଇନରସି
Oh, I had a dispose of me.
Dispose of.
Where is allowed? ଲେଖା ହେଇନି ଆଇ Look, IA number 1850/2025. Order has already been passed on this application on 8/9/2025. Therefore, the IA is disposed of.
Next day I filed the corrected cost articles.
Huh?
Next day I filed the corrected cost articles.
Phrase cost title is also on record.
Say next day.
The phrase cost title is already on record. Yes, now we move the application.
Upland is convicted under section 302, read with the RM second manner, 25 and 27. And sentence is life imprisonment. Relied upon the evidence of PW1.
Your bail application was not rejected earlier or rejected?
This is for the first time.
And have you supplied the deposition copy?
Paper book I have received.
Paper book is there.
And deposition also I have supplied to them.
So first tell us that since when you are in custody?
5 years, 10 months is completed on 27/11/2019.
7/11/2019.
2019. I had supplied the
Eyewitness?
Yes.
PW?
P4.
PW4 was eyewitness.
My lord.
Single murder.
Yes, my lord. P4 eyewitness, P5 and 6 leading to discovery.
Just PW4 को पढ़े सुनो. अच्छा डॉक्टर कितने नंबर से पढ़ जाओगे?
15, 14 and 15, madam.
These are doctor.
Yes.
PW14 and
But one thing, madam.
eyewitness 5 or 6 also leading to discovery.
Leading to discovery. PW4 eyewitness, he also identified the accused in the TA period.
कौन सी कोई सी पढ़ ले?
Madam, one more
Paragraph?
thing.
My paragraph 2, my lord.
2 हाँ पढ़ो.
I heard a loud sound. I went near well of the house and saw that one person was fleeing away from the backside the barrier of the house of the deceased, holding a black color gun. I saw the face of the accused from the light emanating from the electric pole. The accused turned on the motorcycle and fled away.
So eyewitness mainly in the sense that he saw the appellant fleeing out.
Fleeing it,
That's
yes.
all. Yes.
From the facts, it is coming that no one is the eyewitness, madam.
And
The
that's
statement of the
actual commission of murder, there is no eyewitness.
No, eyewitness. The deceased had extramarital relation. Deceased married lady. She had extramarital relationship with the present appellant. 3-4 times the deceased eloped with the appellant. Finally, she did not agree with the appellant. For that reason, on the date of occurrence, the present appellant came to the house of deceased, entered into his house. When the deceased did not cooperate to the accused, fled. The occurrence took place inside the house.
In the house of the who?
Deceased, in the dead hour of the night.
But you come to paragraph number 3.
I went to the house of the accused.
Accused and saw that the deceased was lying.
I went to house of the deceased hava katha.
Okay, confusion. Yeah. So that is in the deceased house, the deceased was lying on the bed and the informant and other family members were crying. So who is the informant?
Informant is my lord.
steps on the PW1.
Son of the deceased.
No, he's the steps.
He saw the accused for the first time in his life. In
Yes.
cross-examination,
Why
para
okay.
4 also
Why-
it says.
The sons
I
of-
saw the accused person on that day from a distance of 15 feet. I saw the accused for the first time on that
Yes,
day.
yes.
I had no prior knowledge about the name of the accused. The accused were wearing t-shirt and jackets also.
PW1 टा होची तार कौन होगा deceased रो?
son
तार माँ माने deceased रो पुआ होगा ना?
हाँ.
Rohit Das, PW1, he says that the deceased was my mother.
Yes.
Now, what he says that on that day, what has happened, myself, my wife, so-and-so were sleeping. And my father got up a so-and-so gala. He saw my mother was not in the room. Based on search, he found just outside the corner of the bathroom She was bleeding profusely. My wife also found one live cartridges once on the spot. Thereafter, we made the deceased lie and the blood was oozing. My uncle was once seen the accused crying out. মানে ইয়ে নিজে भी দেখিনি সে বলছি my uncle Shyam Rohidas.
Sam Rohidas
Shyam
is
Rohidas is
PW4.
PW4, right?
Yes.
On the previous occasions also, earlier accused abducted my mother on ground points once. What about this criminal antecedent? Because it's a case where he is gone. The appellant seems to have used gun, and the postmortem report is also that it was the
Gunshot.
case of gunshot.
Gunshot and ballistic report also
That confirmed.
confirmed.
That gun was recovered from the position of the
Yes.
and was examined, and the ballistic opinion.
Yes.
is
5 and 6 are leading to.
So give. Are you having that information about the criminal antecedent?
Criminal antecedent at Jharsuguda police have obtained at Jharsuguda there is no. He is from
ସେଇ କେସ୍ ଅଛି ଯୋଉ 4 ମାସ
No, no, this man is not from
ତାକୁ ଯୋଉ ନେଇଥିଲା abducted କରିକି ନା
Sundargarh.
yes.
Luharpada Sundargarh.
ହଁ ସେ 4-5 ମାସ ପୂର୍ବରୁ ଯୋଉ ସେ ସ୍ତ୍ରୀ ଲୋକକୁ ନେଇ ଯାଇଥିଲା ସେଇଟା ଗୋଟେ ଅଛି ପ୍ରିଭିୟସ୍ ଆଣ୍ଟିସିଡେଣ୍ଟ ହିସାବରେ ସେଇ ଡିସିଜ୍ଡ କୁ ଏବେ ଯୋଉ ଡିସିଜ୍ଡ ଅଛି ସେଇଟା ଅଛି 4-5 ମାସ ପୂର୍ବରୁ ଗୋଟେ ହେଇଥିଲା that is the stage of the
What is the report? Only no case.
Apart from say previous case.
সেইটা তো
Yeah.
অবশ্যই।
And only 5 years, 5-6 years in custody.
My submission is a real culprit might be the someone else manner here. This is my submission and from the fact I can.
After vacation.
Wait till vacation.
Yes, next.
Item 20.
ସୁଲୋଚନା ପାତ୍ର କେତେ ଦିନ ଡିଲେ ଅଛି 9 ଦିନ 302 କେସ୍
My lord.
POCSO Act.
POCSO Act notice.
IA number so on. So this is an application for condonation of delay. Since the petitioner has been found guilty under section 6 of the POCSO Act and sentenced to imprisonment for life, let extra copy of the appeal memo along with the application for condonation of the plea be served on the land council for dispute, which will be sent to the IAC of so-and-so police station for its service on the informant of the victim program. पुरुषोत्तमपुर PSS number so on. बाकी से जो अच्छी तंग बाणी में जो
वकालतनामा interest
वकालतनामा से उड़ा के सब जो अच्छी फॉर्मेट है वो लिखी दे ना yes and matter be placed application for condonation of delay है ना consideration of the interim application for condonation of delay. Yes.
Item 21.
46 days.
What is the
It is
outcome
also
here?
6 POCSO is there.
The POCSO condition. 302. 302 and 366. 201 रे मध्य ହେଇଛି 344 रे ହେଇଛି 363 ହେଇଛି but no separate sentence. But you have been acquitted of the charge under section 6 of the POCSO Act. And 376. 37. That is in paragraph number 9. 16 now. In the ultimate result for the reasons assigned in paragraph 9, the accused so-and-so is found not guilty. No? So let's on to IA number so-and-so. There is an application for condonation of delay. The stamp reporter has pointed out that there is delay of 26 days, considering the submission made by the land council for the respective parties, and since the petitioner has been sentenced to imprisonment for life, we are inclined to condone the delay. According to delay is condoned, IA is disposed of, hard admit, call for the trial court referral. Yes.
Item 22.
Ram Kumar Sahoo. সেটা কোনটা দেখি first time secular statement level non-appears for the one down. Non-appears for the petitioner. It's a civil review of the year 2000. The civil review petition stands dismissed for non-purchase.
Item 23.
OJC number 8912. It's a dispose of case. তাদের recall petition সেটাও সারলো
Data disposal case. Data disposal case.
এইটা লিখি জানতে এইটা লিখি জানতে মিসকেস ফর কন্ডোনেশন অফ ডিলে নন অ্যাপিয়ার্স করি নন ডিসপোজ অফ নন প্রসিকিউশন ওটা এই যে মিসকেসটা কন্ডোনেশন অফ ডিলে আউ অলসো এই যে দুইটা সিকিউরিটি দুইটা ডিসমিশন এইটা মিসকেসটা বি ডিসপোজ অফ করবে তারপরে এইটা হচ্ছে ওজেসিটা অ্যাকচুয়ালি ডিসপোজ অফ কেস বাট তাদের গোটে ফাইল হয়েছে মিসকেস ফর রিকলিং দি অর্ডার হ্যাঁ না নন appears to praise this application accordingly miscase stands dismissed है ना तो এইটারে প্রথমটারে civil review petition dismiss হবে non prosecution so also this miscase obviously है ना and এইটা সেকেন্ডটারে miscase যেটা equal of the order সেটা dismiss হবে है ना yes
Item 23.
non appears for the petitioner. Nobody is appearing on this.
Very old matter.
The review petition of the year 2007, defects have not been removed. Review petition stands dismissed. Yes. Next.
Item 24.
Non appears, defects not removed. 2007 dismissed. Next.
Item 25.
25, your lordships, last time when this matter came inadvertently, my associate did not understand, but it's not become infructuous. A disciplinary action was under challenge. I wasn't there, I was that. He wrongly submitted that it has become infructuous.
What was the prayer in the writ petition?
See, what a initiation of a disciplinary action is under challenge. And a stay was also there.
So disciplinary proceeding is not concluded.
The final result has not been allowed to proceed, but there's a jurisdictional issue that that person could not have issued the show cause at all. And of course, meanwhile, the person has retired, but the disciplinary action, he's not getting his pension. So unless this is not decided that provisional pension, that person is there. So it was very much alive. I mean, the cause.
You are asking for recall of that order.
So the board se koi dala.
What do you say, Mr. Tate?
Wrongly say.
Item number so and so, there is an application for recall of the order dated so and so. Swami Rathal and senior advocate appearing for this one, that he or associate inadvertently made a submission on 28/7/22. That matter has become infructuous. In fact, the matter not become infructuous, and therefore the order dated so and so be recalled. The matter will be taken up.
Can I brief for a
Adjudication. Land Council for the state has no objection. Accordingly, the order dated 28/7/2025 stands recalled. Yes, the pleading completed.
written notes bhi achi.
The matter be placed for final dismissal. Yes, next.
For date if you're like.
Date অভিজ্ঞতা হইপারিবন যে ছুটি পড়ব দিব
Immediately after vacation.
Last.
দুর্গা পূজা হলিডেজ করতে ফাইনাল শেষ পূজা না
Item 26.
Yes, Mr. Mahanti.
This case, moment, Allah, Dr. General, that is just remove the defect. Petitioner is out of country and it's taken us 2 weeks after, madam, so that I will remove the defect.
Limitation अरे अपन स्टेट नबा कथा
সেটা নেই পারলি because petitioner is out of country, madam.
1057 days.
Madam, though I, because the certified copy of the order has not been filed. Only that reason, that's in 2 weeks' time.
The land council for the petitioner is for an adjournment for 2 weeks. Put up this matter after Durga Puja holiday. Yes.
Item 27.
Can it be finished or we will take up on Monday?
We should take up on Monday. It cannot be finished today.
That is why I was saying.
Mr. Mahanti is also with me.
No, because after lunch, it's a different bench.
Ah, yes, I know that.
Brother is sitting on the full bench and
No.
it's.
Not convenient for us. But what he has given that the documents, I have verified, it is no way concern in the matter.
No, it's all right. I think we heard the matter to some extent, but.
Maintainability point.
Maintainable. And you got that full bench judgment?
Yes, I have got that. I will analyze, I will apprise your lordship. And subject to 2015 Supreme Court judgment.
Justice Deepak Mishra's judgment.
Yes. I have marked everything right. Monday. Let the same position comes there.
No. It will be in the, it is already in the top of the list, so there is no question of entry of any other matter unless a old matter has been specifically directed to be listed on 15. These are all serially listed.
Yes.
So 16, 18, computer will not allow now the system. It's
we can only say that be positive.